just one moment. Did I take my pens back with me and not? If you could just, I can find them, but I'll use these. That's fine. Thanks. Sorry about that. And I'm sorry we kept you waiting, a variety of reasons. But this is not a case where we're going to be under time pressure to finish this afternoon. So just while we remember, if Mr. Malik and or you are in a position to tell us now about the factual queries we had, let's get them down now rather than forget about them later.
I'll give way then.
Yeah.
Okay. So first, about the marriage.
Yeah.
So the marriage took place in Turkey on 9th of October 2010. The marriage is recognized as valid under the UK law, and therefore it is appropriate to refer to the appellant's wife as wife.
Okay, thank you. I think I've misunderstood the facts. I thought that they were married in this country before his first removal, but no is the answer. No.
No.
Okay. No problem.
Secondly, about the sentence. So the appellant was arrested on 21st of December 2015. He stayed on remand until 2nd of August 2016 when he was sentenced.
Yes, I see.
And he was released on 9th of September 2018.
Thank you. That's very helpful. That explains it. She had a long period on remand.
Now, there is no finding in the first year tribunal's decision that the appellant is able to provide support from Turkey. We both have checked the position, and that is the case.
Thank you.
Well, K and D are brothers. There is no other siblings or sister.
That was just a misunderstanding by me. Thank you.
My instructing solicitor has checked the file. Unfortunately, there's no full note of the hearing. But my solicitor thinks that the authorities were referred to by the judge, by both advocates. What we have done, if that is of any assistance, is prepare a document that provides full citation of the four.
That's very helpful. That would be helpful, yes. So at least we know what the cases were, even if we don't know.
Now, this is what.
This man has seen this, presumably. I mean, it's hardly like to be controversial, unless, as you say, there are two cases to AA in Nigeria. But
yes, and there are two cases with MA Somalia, and this is the best that we could have done. The other AA in Nigeria is not about deportation. The other MA Somalia is not about deportation. So the cases about deportation and the public interest are these cases. Can I just say this, that Chiari and Bendlos, there is discussion in that judgment about the public interest in deportation of foreign criminals and how to conduct a proportionality assessment. A Nigeria is a deportation case where Hajj Iraq was considered. It was decided ultimately by the Supreme Court.
Yeah.
LC China is a well-known deportation authority on public interest. It was considered in NA Pakistan. Emir Somalia is also a deportation authority which talks about public interest and deportation of foreign criminals. So this is the best we could have done.
that's very helpful. Thank you. So what we can draw from that is that at worst, at the moment that he was writing his judgment, but more likely in the course of the hearing, he had been referred to AA Nigeria,
Yes.
which we haven't yet looked, but I have a sufficient recollection, certainly refers to HA Iraq in the Court of Appeal. I think sets it out quite extensively.
Yes.
But we'll check that. So the criticism that in those first few paragraphs of the judgment, of the reason section of the judgment, the judge didn't refer to the case law on this aspect is slightly reduced. he'd referred to them later, though only in this very generic way.
Yes, but you have my say. I'm not asking the court to uphold the decision simply because of that paragraph.
I know you're not, but it's just part of the useful background.
Yes.
Thank you. Well, that any of that you need to comment on, Ms. Mannion?
Well, yes, just by way of a health warning.
Yeah.
It's firstly that we don't know that these were the authorities the judge was referring to, because of course he doesn't give them any real consideration.
No, but just pause it. That unless there's a particular reason to doubt, I know in immigration where it's all alphabet soup, there is a risk that two cases may. From my general knowledge, these feel like the right cases.
I don't go so far as to make a submission that this is wrong, and I'm
We'll be
grateful.
careful.
But there's a health warning that we can't be sure.
Okay.
AA Nigeria is a little curious in that at paragraph 9 of that authority, and we don't have it in the bundle, so I'll just make it for your lordship's note. They do the court indicates that it's not necessary to refer to a proliferation of authorities in this field. You should be referring to NA Pakistan and to HA Iraq, which of course aren't referred to. So if one is taking into account AA Nigeria, that's a curious way in which to indicate it.
Fair enough.
And the other aspect is I have been provided with the appellant's skeleton argument before the first hearing, and I'm afraid I've only been able to skim it. I wasn't able to see any of those authorities referenced in it, but
so this is in fact from the other side.
Yes.
Yeah. Well,
and
you've given it to
must
them.
have an opportunity to have a look
well,
at it.
They can have a look, and if they disagree.
But it doesn't appear on the face of it that it was provided.
Yeah.
And the Secretary of State, I'm told, is very unlikely to have provided a skeleton argument at this level, though I have been shown an attendance note which says, very much in general terms, made submissions on this areas of the law, unhelpfully for our purposes. But no list of authorities to which the tribunal was taken.
Thank you. I'm very grateful for a lot of work done by those behind you. I hope they got some lunch. I think we now know as much as we're ever going to know about the hearing. Just while we're on it, and this is only deep background, there's no special history about why it took so long between hearing and reasons?
Well,
was it COVID time?
It's certainly that may be an aspect of it, although I don't have express instructions.
No.
The back of the bundle, while we're on this point, does allow some tracing of the history, because you can see at tab 22 the decision.
Yeah, sorry, but cross purposes. You may want. I wasn't talking about the time it took for between 2018 and 2021. I was talking about the time it took between March 2021 and October 2021 for the FTT to provide its decision.
No, I'm afraid I don't know.
No, well, we probably will never know. But
consequence of
yes, that's. I wonder whether it was COVID related. No, I mean
it's
you may be.
So it may have been. It is in 2021, so it may have been working off site. I don't know what.
Yes. Again, if there was a simple explanation, it would be nice to know it. If there isn't, it's irrelevant, and so we'll. On the point you thought I was asking, no, you'll deal with that if relevant in your submissions. I'm not sure it is actually relevant, seeing the way the argument's gone, but we'll see.
Yes, only into that observation about whether the Secretary of State was it was a priority or not. Well, I was just about to.
My lady has.
So just the date that you gave us for the marriage in Turkey.
Yes.
9th of October 2010, I think you said.
That is right. Yes.
It's just that at page 122, which we were just taken to for a completely different reason. It seems to say the date was actually the 15th of March.
Yes, and I think that is the decision that appears in either the FTT or the UT decisions.
Both. Yes, sorry, I misheard that. Then yes, the date is in March, and the emergency travel document was used to leave the country.
Yes, so that's right. So it is what I actually put to Mr. Malik. That ceremony took place while he was still in this country.
Yes,
the answer may be that they had a full marriage in Turkey later.
Yes, and on that basis, entry clearance as a spouse was granted.
I see. Okay, well there you are. The two are
So a nikah in this country is not valid under
Yes.
English law.
That's right. So the 15th of March would be the nikah.
Yes.
Even the Secretary of State refers to got married.
Yes.
Yeah, okay. Thank you. That's very helpful. This again, this is more just background. It's not to decide the case, but one just likes to get these things right. Thank you.
I was going to take your lordships and your ladyship to HA Iraq very briefly before
Yes.
reading the authorities, and that's at tab 5. As you know, the court in HA Iraq looked at the unduly harsh test under subsection 5, the exception 2 element, and also at the compelling circumstances test under subsection 6. Just to flag at page 95, paragraphs 2 and 3. Paragraph 2, Lord Hamblin, with whom the other justices agreed, dealt with medium offenders, and at paragraph 3 he deals with serious offenders. And so paragraph 3 is important for our purposes.
Yeah.
And the line I rely upon is the final sentence
Paragraph 3.
of paragraph 3. As the very compelling circumstances must be over and above the exceptions, whether deportation would produce unduly harsh effects for a qualifying partner or child is relevant here too. And so again, that there's a logic to using the exceptions as part of the methodology. In that case. As to the substance of the decision, at paragraphs 41, their lordships confirm, and that's at page 104, the self-direction in respect of unduly harsh that a tribunal is expected to make. That's the MK self-direction.
So sorry. Which paragraph?
Paragraph 41.
Yeah.
And that's going to lead to a self-direction which should be made by tribunals when undue harshness is in issue. And my submission would be, therefore, that it would be appropriate in a subsection 5 case, but also in a subsection 6 case. Paragraph 42, the court goes on simply to confirm, again, it's an uncontroversial point, but that the test in subsection 6 is at a higher level than the elevated level already found in subsection 5. And indeed, that's my Lord's words from the Court of Appeal cited there.
But not as high as compelling circumstances.
Yes, and of course here we're dealing with the top of the tree, the very compelling circumstances. And then the test itself, the very compelling circumstances test, is dealt with from paragraph 46. My learned friends, taking you through it, I would just draw attention in particular to paragraph 50, which is where the Supreme Court approves the paragraph in NA Pakistan that I've taken you to, paragraph 30, about the serious offender. They then go on and deal with 32, which I didn't take you to because it confirms medium offenders, and paragraph 33, which I took you to show that the deportation will be rare in a very compelling circumstances case. So again, a approval of those passages at the highest level. What can be derived then from those two authorities? My submission, firstly, the perhaps trite point that the public interest in deportation of foreign criminals is high, and higher still in the case of a more serious offence.
Sorry, just do it. So one.
Public interest in deportation of foreign criminals is high, and higher still in the case of a more serious offence. that cases which will meet the very compelling circumstances test will be rare. That in approaching the very compelling circumstances test for a serious offender, it's usually sensible to consider the subject matter scope of the exceptions, and if they are in scope, it will be necessary to consider their level. That is the level of whether one can achieve them. And that is necessary in order to properly establish whether they are over and above the exceptions within the meaning of the statutory language. That's what I say about the case law for a moment. I'm going to come back to the Court of Appeal in HA Iraq in a moment when I've dealt with the passage that my learned friend relies, to deal with the passage my learned friend relies upon most particularly. If I can turn now then just to the FTT decision at tab 18 of the bundle to look at the decision which the upper tribunal was dealing with. The operative reasoning begins at paragraph 31 and page 90. You've been taken through it, so I won't take a great deal of time, but I would draw attention to, obviously, paragraphs 35 and 36, where the test is set out. Because although the test correctly identifies that the appellant is a serious offender, and cites the test, the public interest requires the appellant's deportation unless there are very compelling circumstances over and above those described in the exceptions to deportation set out in the immigration rules. The very next passage says that the exceptions to deportation do not apply to the appellant.
Why?
Now, that may not be wrong as a matter of applicability, but it shows as a starting point, no recognition that they are nonetheless relevant and I would submit a necessary analytical stage if the subject matter is in scope. So first of all, one might say that the first tier tribunal appears to be directing itself by stating the correct test, but then by saying that it's not going to the exceptions don't apply, and then goes on to treat them as not just not applying, but as of no relevance at all, despite the statutory wording and the wording of the test. Now, even a cursory understanding of NA Pakistan, or indeed AA Nigeria, which required you to pay attention to NA Pakistan, would make it clear that it was most definitely relevant to understand the exceptions and the scope, because of the passages I've cited to you this morning. And thereafter, the FTT is good to its word because it doesn't go on and consider the exceptions in any meaningful way at all in substance, so not in form and not in substance. And there is no, as I understand it, dispute to this. Ms. Malik says for the appellant, well, they didn't consider it, and that's because they didn't need to. But it is quite clear that there was a wholesale non-consideration of the exceptions. So you have then at 37 perhaps a bare bones indication of private life characteristics, but not by reference to the types of elements of private life that are relevant to capture exception 1. At 38, there's confirmation that there is a parental relationship that had been an issue before the FTT decision, so it's necessary to have made that conclusion. Paragraph 39 refers to the best interests of the children and notes that the relationship with the child D is particularly strong. And 40 then deals with the some other considerations of character, including having spent 2 years out of prison and the availability of other family members for support. Then it turns to the public interest at paragraph 41. It was submitted to you that this consideration of the public interest is really not, this paragraph is really not talking about the public interest, it's really just talking about the private interest of the children or the private life or family life interests of the children because of their emotional ties with the appellant. But that cannot be right if you read the first three sentences together. The paragraph begins with acknowledging the public interest in deporting the appellant, so setting the stage as a public interest paragraph. However, there is also a public interest in keeping the appellant in the UK, and then goes on to say why. Firstly, the financial and then the emotional elements. But the financial elements are what are picked up again in sentence 3. If the appellant was deported from the UK, there would be a considerable additional drain on the public purse. That makes sense in light of there not having been, as you've heard, a finding that there would be any financial support from Turkey if the appellant were deported, because the point is, in the absence of any financial support from the appellant from Turkey, the mother and children would need to have further support from public funds. That is, in my submission, a very clear drawing on a different public interest to the public interest in deporting the appellant. It is seeking to draw out a wholly public type of interest in talking about the drain on public funds and public resources, and give it a value and a weight which is set expressly by the word however, as against the statutorily stated public interest in deporting the
Can we
appellant.
test it in two ways? Supposing he had said, however, there is also an interest in keeping the appellant in the UK, then everything. So just leaving out the word public and down to the word significant issues, that would be wholly unobjectionable, wouldn't it? It's really just stating the other side of the balance.
Whether or not that would, it's not what it was saying, because of the first sentence and the third sentence, and indeed the word public in the second
No,
sentence.
but I'm just
One
really
has
trying to draw out that it is the characterization of it as public that is crucial to your submission.
Yes.
The actual substantive point that the judge was making, shorn of that element, was a perfectly reasonable one.
Yes and no. If he was talking about the private life or family life interest of the children in having financial support from their father, then of course that would be classically on the family life part of the Article 8 balance. But the fact that that is not what the tribunal is saying is shown by the final line, which is to say they aren't going to lose out on financial support, so that this is not going to equate to hardship for the children, it's going to equate for hardship to the public purse. So it's not a private or family interest. It is only a public interest, and and the judge expressly makes that clear, both by calling it a public interest, by addressing the topic of public interests, and by saying the way in which it is a public interest in the third sentence. Yes, I accept that removing financial support from children can affect their family life by creating a situation of hardship for them. Because of the public safety net here, that won't come to pass.
I mean, most ordinary people would say, and also for what it's worth, although public budget, of course, is in trillions or whatever it is, on the whole, it's a good thing the public isn't having to pay. Not allowed to, there's not a relevant consideration at all.
In my
Doesn't
submission,
it
no,
go to-
not where the statute has said what the public
Okay.
interests are, and where Parliament can be taken to have understood that there are in many cases either competing or a multiplicity of valuable public interests at play in any given case. That is why Parliament set out, and I gave the history about that in the case law, Parliament set out to simplify this and to narrow the types of matters that could be drawn upon by courts in identifying the public interest. The public interest is set and clearly set and should be respected. I say that, of course, with the caveat that had it been construed as a private or family consideration, that would be different, but it isn't. It's construed as a public one in reality and not just in name when one reads the whole paragraph together.
I mean, I'm sorry, I'm just testing one more rather extreme example, but it could happen. Suppose a child of a foreign criminal is having very expensive treatment on the NHS. And the fact is that if the person stayed behind, they would, because of the work they were able to do and their resources in this country, be able to pay, and not just be able to, but would pay for the treatment privately. That's an irrelevant consideration as well in this context.
Well, that's just another drain on the public purse. It doesn't
Yeah, no,
matter
I think
which public
that's
budget.
logically, I think that has to be your position, but I just wanted to test it against a case where the sums might actually be quite large.
Yes, and one might say the same for a private school no longer being paid for, so that they become
Yes, no, I see that. Thank
in state school, and therefore in that way a drain.
Thank you.
Then at paragraph 42, the first tier view is taken of the delay in deciding the appellant's human rights and refugee convention applications. My submission is that the time it's taken is irrelevant, but it's in any event incorrectly stated, and that's, we'll see from the upper tribunal in a moment what they say. The application was not, the first application or the first decision in 2017 was under appeal and waiting to be heard by the first tier when when the asylum application was made, and it's that was decided much later, but nonetheless before the first tier came to consider this matter in March 2021. And I don't know if it caused any delay to the hearing.
We get that from paragraph 4, didn't we? Of the FTC decision. I was trying to trace this through. 4 or 5 is the history of what happened between the conviction and the period we're now looking at.
Yes, so at 5 you have the deportation order, and that was appealed. You also have the appeal being made in the appeal papers are, or the appeal application is at tab 20. Don't propose to take you to it, but you have it for the dates. So
Sorry,
that appeal was in process waiting to be heard.
wait, one. Sorry, I'm being slow. 5, the decisions are made. Technically, there are 2 decisions.
Yes,
At the beginning of August.
yes.
Where do we get the appeal? What's the date of the appeal?
The appeal is lodged on the 17th of August, and you get that, my lords, by if you turn to the back page of tab 20, and you just see right on the final page just the date there. That's the appeal being lodged and the date that it was lodged.
Okay, so I'll just write it in here. 17th of August.
Yes.
Yes, carrying on with what's the history thereafter? I mean, that was all.
Yes,
You'd expect
and
that
then
to be a
if you-
hearing in late 2017.
Yes, well then if you I don't know why there wasn't a hearing immediately following, but then if you turn again 1 tab forward to the front page of tab 19, you see a little more of the immigration history from the refusal letter of the 14th of January 2021.
This is for the asylum claim.
The asylum claim, just to make clear there, the 17th of August 2017, you lodged the appeal against the deportation decision. On the 26th of June 2018, you claimed asylum. And then, in fact, we have a different date for the release from custody, but there or thereabouts.
It's a bit confusing anyway.
Yes.
He was in
And-
what's bail?
Well, an application for immigration bail following
So-
the conclusion of his criminal sentence of imprisonment. That's a slightly different date, but
Give me 1 second. Yes, I see. It's a slightly different day. It doesn't really matter. But he would have been entitled to be released from prison, presumably a little bit earlier. But then standardly, if you're awaiting deportation, you remain detained unless and until you get immigration bail. We don't know how long that period was, but not
Okay.
very long.
No, and then it wasn't until the 14th of November 2020 that the screening interview was completed. I don't know how much, certainly not all of that delay is explained by COVID by any means, but some of it perhaps might be. It's not very clear if you read the sentence through what date, in fact, the screening interview took place. But that's the asylum claim, and then also the human rights element was again refused on the 14th of January 2021, shortly before the tribunal hearing in March 2021. So,
sorry, your appeal hearing is scheduled.
Yes, to be held on the.
That's the deportation appeal. Must be, mustn't it? Because there hasn't yet been an asylum decision.
Yes, well, until then. And so that's what I mean. I don't know if that then caused the first tier tribunal hearing date to move forward to March. I'm afraid I just don't know. But nonetheless, the tribunal hearing date is in March.
I don't know how much time we need to spend on this, but I don't mean this rudely. It's you who want us to. Going through this, where it gets, Mr. Malik, it's another matter, but where it goes, there does look like a pretty obvious series of delays. There's a delay, not all touched by the Secretary of State.
Well, that's really the point, that the inference made in paragraph 42 of the first tier tribunal is that the amount of time shows a lack of priority for the Secretary of State. Just as a matter of fact, the chronology of events doesn't support that. It supports that it took a long time for the tribunal hearing to
I mean, the most likely explanation, we can't tell you, I'm not too bogged down in this. The most likely explanation is that the proceedings were effectively put on hold. Otherwise, his appeal would have been heard in late 2017, or perhaps some delay early 2018. We don't understand why that didn't happen. But as soon as he made an asylum claim in June 2018, it would have been reasonable, not necessarily the right thing to do, but understandable that everybody said, well, let's put the deportation thing on hold until we have an asylum decision. That's the most likely explanation, isn't it?
It may be, but that level is guesswork. All I'm really saying is what I'm able to say on the papers, which is that it isn't a matter of the Secretary of State hasn't bothered dealing with this, and therefore they...
No, the one lot of... I take your point, but the one lot of delay, which
2018 to 2021.
From June 2018 to wait 2.5 years for a screening interview.
No, the screening interview does take place in 2020. That's all.
Yes, but but the claim was in 29th June 18, so it's 2.5 years, isn't it?
Yes.
And then a bit more for a final interview, and then another several months for a decision. Alas, that is not an unsurprising, well, it's very surprising, but it's not an unusual situation for asylum decisions to take that long. That is a criticism of the Secretary of State, but it's maybe not be one that shows he didn't take it seriously. He's just in with everyone else having an incredibly long time to have his asylum decision decided. Is that a fair summary?
Yes, I think I have to accept that. Only really with the caveat that the chronology doesn't help. It is a little more filled in than the FTT.
No, thank you.
Suggested.
Yes.
And then finally, here at paragraph 43, you have the apparent balance that deals with the real matters in issue in this case. That is the family life matters. And the ending with the bare conclusion that I find the offence removal from the UK would be disproportionate in all of the circumstances. Now, a balance that may be, but it is not one that even begins to grapple with whether deportation would be first unduly harsh, or even harsh, or how one's to assess that, let alone going beyond it, neither in name nor in substance.
It certainly doesn't use the language of unduly harsh.
No, but it certainly doesn't use the language, but also doesn't undertake such an assessment. There's no consideration of this being an elevated standard or let alone elevated over and above what you would expect to succeed with if you were a medium offender.
But is that a necessary exercise? I mean, as long as the judge understands what's meant by very compelling circumstances, which are an ordinary English phrase, and any immigration lawyer knows that it's a very high test. You don't need to, as long as you said, this is the test I'm applying, why do you have to say, and that's more than unduly harsh, or that's very, very rare, or any of the other things that appear in the case law? You're applying the statutory language.
Well, my submission is that it's not just a failure to supply that type of language. It's a failure in the analysis to demonstrate that it's been considered at all by reference to any language that acknowledges the rarity, any languages that acknowledges these must be especially compelling circumstances, or anything that acknowledges the heightened level firstly at subsection 5, and then that this goes still further. And the case law was there in NA Pakistan that made very clear at this stage that that is the type of process that one needs to go through. Certainly, it's the upper tribunal's position that it was necessary in this case, and I'll come to that in a moment.
Yeah.
But I must say that it was the right conclusion on these facts, where the subject matter and really the whole appeal was based on the relationship between the appellant and his children, and in particular the child D, and how that support was needed and the effect on those other family members. That brought this wholly within that structure, so that we are at a loss to understand really what level of severity and what level of harshness this is pitched at. If this had been a medium offender, we would have known, and now we have the supposedly rare case, and there is no anchor in this authority to show how that process has happened. That's why it's so important in my submission in a case like this. Then let's turn then, if we can, to tab 10, which is the upper tribunal. Just briefly on this, the upper tribunal sets out the legal framework from 26 onward in my submission faultlessly, and confirms the public interests at stake, again within those passages, identifying correctly the appellant as a serious offender. The discussion begins at paragraph 31. The first complaint the appellant makes is that the upper tribunal purported to set down some form of legal test or a requirement in law to make a definitive finding on the exceptions. So it is necessary to look at what the upper tribunal in fact said, and the extent to which it did and didn't do that. In my submission, the most important paragraphs where the upper tribunal sets out what it's about to do are paragraph 33 and 34. And it's really paragraph 34 that makes clear that the upper tribunal isn't setting out to say that there's a requirement in law to make a definitive finding on the exceptions in every case. It says expressly in many cases the above observation would be a criticism of form over substance and may not amount to an error of law. However, in this case, I consider the judge's failure to approach his reasoning expressly by pursuant to the statutory framework established by section 117C meant he omitted key considerations and failed to consider material considerations. In turn, that led to the judge taking into account immaterial considerations and impermissibly downgrading the public interest in the claimant's deportation for the reasons set out below. it's really important in my
Hang
submission
on one second.
to
I'm just
recognise
making-
that
Sorry,
starting
give me
scope.
one moment, will you?
Yes.
Yes, I was just noticing something I hadn't noticed before. I think, maybe reading too much into this, that in that last sentence of 34, when he says that led to the judge taking into account immaterial considerations. Is the immaterial considerations, as it were, no, I don't know. No, I don't think this works. I was wondering whether that could be mapped onto the way he goes on to structure it, but it can't, I don't think.
My reading of it, for what it's worth, is that latter part relates really to the extra public interests that are identified, and really it's
Yes, that bit is clear. That's two. I agree. But what are the immaterial considerations? Does that map onto?
That's the immaterial considerations such as the drain on the public purse or supposed lack of alacrity on the part of the Secretary of State.
Lack of, sorry?
A lack of speed on behalf of the Secretary of State.
Yes, I see. Okay.
And then at paragraph 35, in the middle of the paragraph, there is, again, just a confirmation of what the approach should be. What amounts to very compelling circumstances is an assessment that must be informed by the extent to which the claimed very compelling circumstances exceed the factors set out in the statutory exceptions to deportation. That must follow from the statutory language. And there the upper tribunal isn't saying there must be a prior and complete determination, which is an arid exercise because this isn't an offender who could ever comply with them. It's saying that you can't reach a correct conclusion without informing yourself about the state in respect to the exceptions. And then, of course, you see where the confirmation that the first tier tribunal judge didn't in fact address either statutory exception. I've addressed you on that. Then my learned friend obviously relies upon the language of prescription that's in paragraphs 36, 37 and 38. But what in my submission the upper tribunal was seeking to do at paragraph 36 is derive that test from NA Pakistan at paragraph 37, which I have addressed you on. It's that which it cites, it's that which it says provides the authority for the position it is taking, and in my submission it was entitled to do so when one looks at the fact that it is not saying this is all cases every time. It is this case where it has led the first tier tribunal completely off track, where the subject matter of the exceptions is wholly in issue, particularly the undue harshness one, which so much case law and court time has been given over to understanding and utilising properly. It is in these circumstances where it will be necessary to look at whether the factors are of sufficient force. And it is in that context and limited in that way in my submission that this language of prescription is used. And perhaps the most helpful in my submission statement is at the end of paragraph 38, the final lines where the upper tribunal says what the first tier did not do, because that's perhaps the best indication of what it says the first tier should have done. What the judge did not do as part of this analysis was consider, one, whether those factors were unduly harsh, and two, if they were, what the factors were of particular significance in that assessment that meant if they took the case into the territory of very compelling circumstances, since this claimant was a serious offender. And that is the language of using this as an analytical tool, as a way of not becoming untethered and providing an evaluation that isn't in recognition of the rarity of a very compelling circumstances case. It is a position which in my submission is supported by what the Supreme Court said in HA Iraq after this decision. Well, in fact, no, just around the same time, after the submissions and before the judgment, because that again confirms, as I've taken to you too, the relevance of the exceptions for the very compelling circumstances test. So, seen in that light in my submission, the upper tribunal was providing guidance, as it should do, to first-tier tribunals as to a methodology to apply in circumstances where the exceptions are in issue, as they were in this case. It is a requirement that was contextualised on its circumstances, to its circumstances, and it comprises the right course in cases such as this, where the subject matter of the exceptions is what's in scope. And provides the helpful analytical tool of the unduly harsh, which allows you to click into the case law that says you must be beyond that level. Just as an observation, the upper tribunal doesn't criticise a failure to consider exception 1. And that, in my submission, is a clear indication that it wasn't shackling itself to an arbitrary set of legal tests. It was saying it matters here because it's in scope, and the fact that it isn't concerned with exception 1 really demonstrates that. Does the approach taken here offend HA Iraq in the Court of Appeal? In my submission, it does not, and that's because of the passage that is relied upon in HA Iraq was in relation to medium offenders. If I can take you then to that authority, it's in the authorities bundle at A4. It concerned, this aspect in the Court of Appeal of HA Iraq concerned 2 medium offenders whose sentences were 12 months and 16 months. The court therefore was not considering and did not purport to provide binding authority to the upper tribunal on the approach to take in respect of serious offenders. That was still coming from NA Pakistan at this time. And that means that while the judgment gives consideration to the practical test that the FTT should take for a medium offender by citing the NA Pakistan test for a medium offender at paragraph 36, there is no like or equivalent consideration of the test in paragraph 37, which the upper tribunal relied upon here and which I've cited to you.
No, but it is what I say in this paragraph is, although in a medium offender context, is about the correct approach where you have to apply subsection 6. And although we say subsection 6 is for serious offenders, that's not right. It's also true for medium offenders where you can't satisfy 1 or 2, or simply, really the point made in this paragraph, don't choose to satisfy 1 or 2. It'd be very unusual that the parties wouldn't try.
Yes.
But the point simply being made here is in a subsection 6 case, so in a medium offender case, it's not illegitimate where you're worrying, was it unduly harsh, or exception 1, was it were the obstacles to integration in his home country insurmountable? You can say, never mind, stepping back and looking at all the factors here, I can say there are very compelling circumstances. That is what we're saying, and it applies to subsection 6 generally. That may not be fatal to your point, but I don't think you can say it only applies to medium offenders.
No, but the starting point is the context. And so the consideration was in respect of medium offenders. So that's simply the background that the passage of NA Pakistan cited
that, of course, yes.
is paragraph 36, and that just for your Lord and Ladyship's note is confirmed at paragraph 30 of HA Iraq. And then if you go then on paragraph 60 it isn't in, it isn't, this paragraph in my submission isn't in no way fatal to my submissions, because there is such considerable overlap with what in fact is said by NA Pakistan in paragraph 37 in the test. The difference is, in a medium offender case, you will have, as indeed your lordship says, you will inevitably have considered whether the relevant exception has
Well, I
been
agree.
met.
That's obviously helpful to you.
So in a subsection in a case where a serious offender is going straight to subsection 6, that's the difference between NA Pakistan, because that says, well, here it's sensible to look first to see if it applies, and if it does, then it's necessary to do that levelling first. So far from saying a two-stage test is not necessary, all that is said in paragraph 60 is that it may, this is at the top, my lord, it may occasionally make the analysis unnecessarily elaborate. Well, there's no dispute with that. Of course it may, and that's why that's why the upper tribunal didn't seek to say in every case and without any consideration, you must dutifully consider exception 1 and then exception 2, and they didn't say that, and they didn't do that. They considered the one that was in scope, exception 2, and said the proper course is to then, when it is in scope, consider it.
Can we just consider the last part of that paragraph,
Yes.
starting from the exceptions? Provide a shortcut for the appellants, not compulsory to take it, to proceeding directly to proportionality assessment, provides a clear answer in the appellant's favour. So why wouldn't that apply in serious cases if it applies in medium cases?
Of course it does, but that is the exchange that we were having before lunch when considering NA Pakistan. It is not a matter of saying that every time one looks at the test for section 1176, one must go through the process of the exceptions. It's about first assessing whether the exceptions are in play by their subject matter. We exchanged, my lady, on the ways in which a case might arrive at section 117C6 without having exceptions type material either as anything other than bit players in the Article 8 case that's presented. And that must of course be the case for a medium offender too. A medium offender may not comply with the exceptions and they may therefore go straight past them because they're not in scope, not because if they are in scope, they must be considered. Whereas if they're not, if they aren't in play, then of course one considers the relationship with elderly parents or the employment prospects that are being offered or all the other aspects that might be making the particular compelling circumstances in that case without reference to the exceptions. So in that sense, the processes are no different. And the main point really is that even on such a medium case, they will inevitably have been considered. And in my submission, the upper tribunal is not really, on a fair reading, requiring more than that proper consideration be given to whether the exceptions are in scope, and then it's to be used as the appropriate analytical tool to assess whether there are very compelling circumstances over and above those exceptions. So in summary then, on the upper tribunal authority, the approach it took in my submission is more careful on a proper understanding. The need to consider exception 2 in this case arises from the circumstances of this case, namely the reasons that were presented on appeal were family life, exception 2 family life reasons, and that it is an approach that's supported by the language, the plain reading of subsection 6 and supported by the case law, and it is not, in my submission, undermined by HA Iraq at paragraph 60. The second complaint with the upper tribunal is that its conclusion involved giving weight to countervailing public interests. My submission is that the upper tribunal correctly identified the public interest in this case. I've taken you to the case law that supports the high value given to the public interest in Part 5 and in particular in 117C, and that the purpose includes minimising the scope to take into account extraneous matters. The appellant says that the upper tribunal misreads the first tier tribunal. I don't accept that. It does not. The passage in the first tier tribunal simply deals with emotional ties as well as financial ties, but it is entirely clear and express that the first tier tribunal's view was that there was a public interest in favour of the appellant remaining in the UK to avoid a drain on the public purse, and that is one which the first tier tribunal is not and was not entitled to identify and give supposed weight to, or give weight to rather. And then the final point is that the upper tier tribunal was correct to criticise the weight that was given by the first tier tribunal to the timescales being a lack of priority in this case. I've explained why it's not as clear on the facts as it is implied, but it is not a relevant consideration in any event. It certainly doesn't necessarily lead to the conclusion that the first tier appears to give to it. I was with, or I have sympathy with your ladyship, because I too read it as something of a postscript. It's not entirely clear that it is part of the upper tribunal's full findings. It's not the third item, although it seems to me the third ground of appeal. So it would make sense if it's included, and it seems to me I have to work on the basis that it is part of the findings of an error of law, certainly collectively, but it's perhaps best to understand it as the first tier tribunal putting reliance on public interests that fall outside of the ones set down in statute.
If you set aside any criticism, is it still irrelevant if all that is being said is that by virtue of those extra years, the relationships and the Article 8 private life was very significantly enhanced?
Well, the period in issue is
Embedded
between release from prison essentially in 2018 and the date of the first tier hearing in March of 2021.
So 2 years.
Of course, that is a
In
period
the life
in which
of a 7-year-old
is significant. Of course, but it doesn't. In the sense that, however long someone is in a particular place, that will increase and embed the way in which they can that their connections within their community are made, and of course it affects the rehabilitation point that Malone Friend took you to this morning. But it doesn't. What it doesn't do is indicate a lack of interest or permit the first tier to say what this shows to me
that wasn't
is a lack of interest.
what I was asking. What I was asking is,
Well, then
a relevance of the type that Mr. Malik.
Yes, and I certainly don't seek to suggest otherwise than that the passage of time must inevitably have that effect. Then the final submissions from me, just the last word on the principles to apply that are set out in Mr. Malik's skeleton argument at paragraph 29. Only these observations, that a number of the passages are set up as critiques of upper tribunal interference, but were actually decided as critiques of Court of Appeal interference with decisions of the specialist tribunal, that being the first tier and the upper tier.
I see. Well, I haven't looked through all of them, but the point does arise at both levels, doesn't it? But the principle must be the same at either level. A point of law is a point of law.
As to a point of law, yes, of course. But there is a sense of that I read in the principles as they were put, that the upper tribunal should have given greater consideration to the first tier's expertise. That is less of a point for the upper tribunal, which is itself a specialist
No, I see
tribunal,
that.
than it is where these authorities are classically used. And in fact, within the authorities in this bundle, that the same principles are cited. And of course, in those other cases, they're cited as observations to make to the Court of Appeal, to say, here, stay your hand, that this court should stay its hand because the upper tribunal is the
Are there no
specialist.
cases that make this point in connection with? I'm pretty sure I myself have criticised the upper tribunal
There
for
are,
interfering with the FTT.
of course, there
On
are
the-
cases
relying
that
on
do
these
all of these
principles.
things. It's simply just to flag, for example, that at 1 and 2, that AH and MA Somalia and the Crown and Jones are all authorities that are in fact directed at the Court of Appeal, not directed at the specialist tribunal. In fact, it's saying you the Court of Appeal, should have had better care for the specialist tribunal. And if I won't take them to you, but if you read them, that certainly Jones is in the bundle, MA Somalia is in the bundle, and MA Somalia cites the passage in AH Sudan, upon which, in fact, we would both rely, because I rely on it for saying that you should give proper respect to the upper tribunal. There's an
Mr.
additional.
Malik relies on 1, 2 and 3, which are each cases relating to criticisms of the upper tribunal for being overzealous in their overturning of the FTT.
He relies on them to say that, but the authorities themselves, in fact, are directed at this court, and in my submission, I rely on them to that extent to say that this is not a case in which the Court of Appeal should interfere. This is a case which the Court of Appeal should give proper respect to the expertise of the upper tribunal. In
I've
addition,
got a feeling that isn't UT Sri Lanka a criticism of the upper tribunal? Can't remember.
sir, I'm not saying that all of them are. So
No,
let me.
you're making a perfectly
Yes.
good point
UT
as
Sri
far
Lanka.
as it goes, that it may be worse for that there may be marginal cases where it's appropriate for the upper tribunal to interfere because of its specialist knowledge, which wouldn't be appropriate for the Court of Appeal to interfere because it's not a specialist tribunal.
Yes.
But this is a point at the margins when all said and done.
Simply that one could write this paragraph of the skeleton argument and replace the upper tribunal in each case with the Court of Appeal, and the authorities would sit just as well. So it's not in that sense, it's in fact some of them are directly that. So it was only to make that point and to draw out a point in Jones, which also, again, it's a well-known point that the upper tribunal has a particular role in guiding the first tier in making both principal decisions, but also how to go about its purpose. And in my submission, that really is how one needs to look at the upper tribunal case here. Finally, and this really is the final point, that in the bundle at tab 6, there's a case of KM, which is not in either of the skeletons, and in fact you haven't been taken to it by my own friend. It is a useful decision in my submission as showing really exactly how this upper tribunal suggested that such cases should be decided, that is, by proper consideration of the unduly harsh criteria, and then this court approving that as a carefully structured ruling where there's consideration of the public
Sorry,
interest.
if you want to take us to it properly.
Fine.
I mean,
It's an example, and my lord, I'm only aware that you don't need multiple examples, so I don't say it as anything turns
You say
on-
asked us to
on
look
the
in our own time at KM as a useful example of a well-structured, well-structured FTT decision.
No, this is, no, my lord, I certainly don't want to give you homework, so let me take you to it very briefly and I'll say what I'm going to say about it. It's at tab 6.
Yep.
It concerns a serious offender. That's clear from paragraph 7, which is at page 125. At page 131, you have a consideration of the upper tribunal judgment, which is described as detailed and carefully structured. And then the Court of Appeal helps us by going through how it is detailed and structured. If you turn over the page, and I can only need to take you to the subheadings, public interest is considered. It's not an example of approval of countervailing public interest. It's an example of how one assesses the weight of the seriousness of the offence. Family life, exception 2, again, for a serious offender. Private life, exception 1, for a serious offender. And then the very compelling circumstances test over the page. There is argument I don't need to take you to as to the various issues that were raised in respect of that. The passage about the approach of the appeal court, there you see those authorities cited again at paragraph 77. And the final point then to make by way of conclusion is the final paragraphs of the judgment at paragraph 117 at page 149, in which the Court of Appeal confirms that the upper tribunal conducted a careful balancing exercise, including a careful assessment of the factors laid out in the case law, weighing the competing considerations, and concluded there were no very compelling circumstances over and above those described in exceptions 1 and 2. And then the final line is the conclusion which the upper tribunal was fully entitled to reach. It doesn't, my lord, I accept, tell you how to do it, but it goes some way to showing that this is a helpful tool that this court has seen on other occasions as a well-structured way of approaching this matter for serious offenders. And that, in my submission, is what the upper tribunal was trying to do on this occasion.
Thank you very much indeed. That's been most helpful, Ms. Manning. Any reply, Ms. Mallett?
Just very briefly, Miller and Friend, towards the end of our submissions, submitted that the principles that I've identified in my skeleton at paragraph 29 do not apply with equal force in appeals from the first tier tribunal to the upper tribunal. The submission with respect is not well founded. It is directly inconsistent with the authority. AA Nigeria, which was considered by the Supreme Court, was a case where the first tier tribunal had allowed the appellant's appeal. The upper tribunal set aside the first tier tribunal's decision as being wrong in law. This court applied these principles to hold that the upper tribunal was not entitled to interfere with the first tier tribunal's decision.
Yeah.
The Supreme Court expressly said so at paragraph 72. This is page 111 of the bundle. It is well established that judicial caution and restraint is required when considering whether to set aside a decision of a specialist fact-finding tribunal. The specialist fact-finding tribunal here is the first tier tribunal. The upper tribunal, the appeal to the upper tribunal is available only in a point of law. It has no inherent fact-finding function. And then you'll see the principles, 3 out of 6 principles. Those principles were then applied to the facts of that case to dismiss the Secretary of State's appeal. So there is no doubt at all that the principles apply in the same way as they apply from the upper tribunal to the Court of Appeal. the principles apply repeats from the first year tribunal to the upper tribunal. You see a reference to Jones in particular there. Yes, my Lord is absolutely right that there's further case law on the subject. I suspect there's something from my Lord as well, making it absolutely clear that the principles apply.
Speaking for myself, I don't think we need to be deluged in case law on this,
Very good.
this point.
So my learned friend took the court to NA Pakistan and made submissions on paragraph 37.
Yes.
That is the paragraph as to which there is a dispute between the parties.
Yes.
You have that paragraph at page 210 of the bundle. Look at page 210. The first sentence has these words: "It will often be sensible." So my learned friend in effect asks you to read in often be sensible. It will often be sensible as will always be necessary. In my respectful submission, there is no justification for doing such violence with the words used by Lord Justice Jackson. Well, this passage was considered by this court in Hatch, Iraq, by the Supreme Court. If it had laid down a principle of law, then one would have expected this court and the Court of Appeal to have said so in Hatch, Iraq. In any event, if you continue reading the first sentence, it will often be sensible. And then it says, to see whether his case involves circumstances of a kind described in exceptions 1 and 2. My learned friend reads that that it says to make a definitive findings under exceptions 1 and 2. So all at its highest, what was being contemplated is that the decision maker will simply see whether the circumstances actually fall within the exceptions. This paragraph cannot be read in my submission as a rule of law, that in every single case it is necessary for the decision maker to make a definitive finding as to the 2 exceptions. Finally, one must read the paragraph as a whole. If you look at the last sentence of that paragraph on the next page, so what is necessary for the decision maker to do is to consider whether the circumstances taken by themselves or in conjunction with other relevant factors satisfy the test in section 117C6. This is what, in my submission, the first year tribunal did. Looked at all the circumstances and took the view that the test in subsection 6 is met. My learned friend then took the court to the first year tribunal's decision. Let me just very quickly respond to a couple of points that she made. So my learned friend's first criticism was about what the first year tribunal said at paragraph 36. This is page 90 of the bundle. So this is where the judge said the exceptions to deportation do not apply to the appellant, and my learned friend criticized that. In my submission, it is a bit too generous for the Secretary of State to criticize the judge for using those words, because those are the exact words the Secretary of State used in her decision. Her decision starts at page 121 of the bundle. Page 125, it is the Secretary of State who said in the third paragraph
Yeah,
that exceptions do not apply.
this is a enjoyable point that does your research credit, but she wasn't really criticizing that statement. She was really criticizing the fact that the FTT then said, because the exceptions don't apply, we don't have to look at them again. They're out of the picture. Whereas on her case, which you've already addressed, she says they remain relevant to the picture because of over and above and because of para 37 of NA. Of course, the exceptions don't apply, but the question is, does that mean they're now irrelevant?
Yes. I mean, you have my submissions in opening.
Yes. Well, we know what you say about that, and we'll have to make up our minds on it. But this particular point, I don't think takes it any further.
Great. I'll leave it here then. So my learned friend then made submissions as to paragraph 41, the public purse point, and she submitted that the impact on public purse is simply irrelevant. In my submission, in a full proportionality assessment, that point cannot be irrelevant. It's just impossible to see how the impact on the taxpayers is irrelevant when it comes to the assessment of proportionality. The submission with respect made by the Secretary of State is somewhat surprising, given that the same statutory provision, the Part 5 of the 2002 Act expressly refers to financial well-being of the United Kingdom and the impact on taxpayers.
Yes, that rang a bell with me.
Yes, this is page 3 of the bundle. So section 117B, you haven't looked at it because although it applies to this case, it's not.
But,
Section-
117D.
Sorry, 117B,
B.
page 3 of the bundle.
2A.
So this provision applies to this case, but you've heard no submissions because it's not really directly relevant. So if you look at subparagraph 3, it refers expressly to the economic well-being of the United Kingdom, the need for people to be financially independent, not being a burden on the taxpayer. To then say that, well, the impact on the taxpayer is simply irrelevant, in my submission is not only wrong, as a matter of, I say this with respect, as a matter of common sense, which is that
You do sometimes get cases, actually there's a tiny hint of it here, but you do sometimes get cases where tribunals say that the foreign criminal, perhaps surprisingly, but there are cases where it is true, is running a very successful business and is providing local employment and so on.
yes,
And that ought to go into the mix.
yes,
It's not quite the same point, but it's a point about the public interest not always necessarily being the interest in deportation, which is unquestionably identified.
yes.
I've often wondered about I've never found that although you see it from time to time in cases, I've never found it particularly attractive. It tends to mean that well-off and prosperous income-generating foreign criminals may have a stronger case to resist deportation than the poorer ones, which is unappealing when they've committed the same offence.
Yes, I think learned friend says that one has to read the whole subsection, and
Yes.
no difficulty with that.
I think our point would be that this is about factors that might support remaining in the United Kingdom rather than factors that resist, that counter the balance resisting deportation. Because, I mean, the point made by the upper tribunal was that the public interest was downgraded by
Yes.
reference to this point, wasn't it?
Um,
So taking the statutory statement of the public interest and then weakening it by reference to this
Yes.
factor.
So the way I would invite the court to read the first judge's decision is that the judge acknowledged the public interest in deportation,
Yeah.
then sets out the circumstances on the other hand of the balance. And one of the many circumstances that he referred to was the impact on public purse. If that matter is relevant, the question of weight was for the first judge. And in my submission, when one conducts the full proportionality assessment, it's impossible to see how impact on public purse is completely irrelevant. Very happy to accept that it would be exceptionally rare to see a case succeeding on that basis alone, in particular where there is the strong public interest in deportation of foreign
Yeah.
criminals. But is it relevant? Surely, in my submission, it is. But assume that I'm wrong about it, and it's irrelevant, and assume that I'm also wrong about the submission that I've made that the judge, the upper tribunal judge, simply misread
Mhm.
paragraph 41, and Milan friend is right. I also made a point in my submissions about the materiality of that.
Yes,
particular
well, you
sentence.
did, and I speak for myself. I think that's maybe the most attractive answer,
Yes. So.
but don't
And,
quote me on that.
yes. So, no, but I would say, Lords, is that you heard no submissions from a learned friend. I hope I'm not being unfair on
It
the
was
question. of
appropriately
materiality.
economical, but I don't think I need to treat that as a concession.
No, I accept. But can I just ask my lords and my lady to look at paragraphs 43 and 46 of the judge's decision. Now, these are the two paragraphs where he's ultimately conducting the balancing exercise. So 43 and 46. So everything else are findings. So the actual balancing exercise is at 43 and 46. Now, where in those paragraphs, I would invite my lords and lady to consider, the judge has attached any weight to the impact on public purse. Nowhere in my respectful submission. So this point, one particular sentence, even if one reads it in isolation, it played no material part in the actual ultimate balancing exercise.
Since, as you say, Ms. Mannion didn't actually address us about this, it probably isn't a reply point. But anyway, we understand what you say about that.
Yes, Milan friend then made submissions on the removal not being a priority point that the judge made at paragraph 42.
Yes.
I make the same point in reply that if one looks at paragraphs 43 and 46, it's difficult to see. The judge did not allow this appeal on that basis, that there was undue or unreasonable delay. Milan friend said that the judge effectively said that the Secretary of State was not bothered about doing anything with the appellant, but this surely is not what the judge said. Finally, the upper tribunal's decision. The upper tribunal used 5 words repeatedly in the decision. Expressly, must, in terms, incumbent, the test. In my submission, looking at those paragraphs, it's quite clear that the upper tribunal judge felt that it was necessary as a matter of law for the first judge to make express findings on the 2 exceptions. And what is missing from the upper tribunal's decision is any self-direction to the principles that I've identified at paragraph 29 of my skeleton. Very grateful.
Thank you.
Well, we're most grateful to both counsel for, if I may say so, very persuasive submissions on both sides. We're going to have to think about this. We've obviously tried to get the decision out as quickly as possible. judgments will in due course be circulated in draft to council for the purpose of agreeing consequential orders, or if they can't be agreed, preparing short written submissions on the basis of which we will decide the outstanding dispute. Also for the purpose of correcting any typographical or small factual errors. I won't read you the Riot Act about the importance of confidentiality of drafts so circulated. You will find the relevant principles in the Consul General for Wales case, with which you will both be very familiar. Counsel General, not Consul General, so sorry. Thank you again, and I should say those behind you, there's clearly a lot of work has gone into this case.
All right, again.